The legislative session of 2016, we had a lot of bills, but there were 4 that were very specifically targeted at our industry that would have done some really bad things to our bottom line. The first one out of the gate was there were going to be mandated inspections for lead-based paint.
Welcome to the Rental Property Owner and Real Estate Investor Podcast, brought to you by the Rental Property Owner Association, providing benefits and services to real estate investors and rental property owners for over 48 years. With your host, Brian Hamrick from Hamrick Investment Group.
Hello and welcome to episode 72. Every day in the news, we hear politicians and reporters talking about the Obamacare law, the budget, and other bills and laws that could affect our wallets and our bank accounts. So all of this may lead you to wonder, what bills are out there that could affect me and you as rental property owners and real estate investors? So here to answer that question today is Clay Powell, the director of the Rental Property Owners Association of Michigan and the RPOA of Grand Rapids. Clay, thanks so much for being on the show.
Hey, thanks for having me, Brian.
Now, a lot of people don't realize that one of the RPOA's primary functions is to represent landlords and investors at the local, state, and national level. So I'm hoping that we can get that message across today, loud and clear.
Sounds fantastic. We've got lots of things to talk about.
Good. I want people listening to this episode to be scared, very, very scared. And I want you to scare them.
Well, there are some very scary things that did not happen, which is the good news.
Good. Well, let's start there. I'm looking back at the past year. What were some of the laws that were out there, either at the local level, the state level, that you were an active participant in preventing from happening? Or that I should say, not just you, but the Rental Property Owners Association.
Sure. In the legislative session of 2015 through 2016, we had a lot of bills, but there were 4 that were very specifically targeted at our industry that would have done some really bad things to our bottom line, mostly inconvenienced us in a lot of ways as well. The first one out of the gate was there were going to be mandated inspections for lead-based paint. If you're not familiar with what that might mean, that would mean that you would have to secure a third party to come in and inspect your property for lead-based paint hazards at every interval of an inspection. So if you're in Grand Rapids, it could be every 2, 4, or 6 years. You're in Wyoming, that could be every 2 or 3 years or 4 years. It could be if you're in East Lansing, that would be every year.
So you're saying whenever you get city inspection, they would also do a lead inspection as well? Yeah,
they would require you to get a lead inspection to identify any lead hazards, if any exist. So extremely expensive and not necessary under a lot of the laws that we have under the federal guidelines and the state guidelines at this point.
How expensive would that be to have a lead test?
It's all over the place. There's really not a lot of folks doing it, to be honest with you. It depended really upon whether or not they were going to allow you to do dust swipes and consider that adequate, or they're going to make you use something called an XRF to identify lead and the components of the house in addition to dust swipes. So anywhere from several $100s probably to several thousand.
Wow. Every time you get city certified, you would have to spend that kind of money.
That's correct.
And you are the RPOA lobbied and successfully prevented this from happening?
We did. We went to the representative that was sponsoring that bill pretty early in the game and convinced him that it was the wrong thing to do for all kinds of reasons, because, like I said before, these things are covered under a federal and state law already, like through the RRP program, and with local housing codes, and that just doing what he was suggesting to do would just add additional cost and, of course, increased the cost of housing, especially in the very neighborhoods he was trying to impact.
Wow. Okay. Well, obviously you were persuasive, because that ended up going away, huh?
Yes, it did.
Excellent. What else was out there that you had to speak out against?
Well, there was another one that was more annoying in terms of being a political maneuver by some legislators that were going to require landlords to register people to vote. I guess maybe we can all imagine why some legislator might think that would be a good idea.
You mean we would be responsible for getting our tenants to register to vote?
That's correct. Every time we would sign up a tenant for a new lease, we would have to register them to vote.
Other than just trying to get more people to want to vote, why would someone think that's a good idea to make that a landlord's responsibility?
Well, I would assume that the constituents of those that were supportive of such legislation felt that they would be captured within the rental market. So if more of their constituents are tenants, it would behoove them to get more tenants registered to vote.
I wonder what would the penalty be?
As far as I'm going to go with that, I think most listeners could probably figure out the rest of that.
Yeah. I'm just wondering, like, if I didn't get my residents to vote, what would happen? Would I?
There was no ramifications for the tenant not voting for you, but not registering. Who knows what that would have been? There could have been fees and fines and et cetera, et cetera. None of that was laid out. It was just basically saying that landlords would have to do it.
I love it. I'm glad you're out there fighting for us.
Right.
What else? What else?
Well,
you got in there?
Here's another one that would have been a big dig into your pocket. There are currently, smoke detector regulations throughout the land and in most communities. If you're under the National Property Maintenance Code, you have to provide a battery operated smoke detector at the very least. And some communities, like the city of Grand Rapids, are very specific about which smoke detectors are allowed. Well, this would have went even one step further by requiring an additional type of technology, the photoelectric technology, be added to the smoke detector. So you'd have to buy a smoke detector that has both the technology, the current technology, plus the photoelectric technology, which those are available. There are very few of them, but they're about twice the cost of the most expensive smoke detectors that are battery operated now. So you can see that if you had to replace all of your smoke detectors with these new smoke detectors at about the best price Home Depot could quote me was somewhere around $32, and that was a very low discounted price.
Per detector, huh?
Per detector. So most rental units have anywhere around about, single-family homes anyway, about 5 smoke detectors in them. So you take that times 32 times if you own 100 properties, you can begin to see how quickly that adds up. So somebody was going to make a lot of money, and it wasn't going to be rental property owners, that's for sure.
Yeah, well, photoelectric technology, that sounds pretty fancy and special. I mean, what does it actually do? Well,
they were trying, I don't remember all the exact details, but I know that it was one of, or the other things was determining when one would capture either smoke or heat faster than the other, and the two combined were supposedly better. There was some arguments about whether that was a good or a bad thing. But really, when it came down to the cost, it was just insurmountable for us as an industry to pay that kind of money for a very insignificant achievement in terms of extra protection.
So what was that argument like when you went to speak about that with the legislator?
Well, in this particular case, our lobbying firm, Karub Associates in Lansing, was able to talk to a few representatives pretty quickly on that one and convince them that it was not in the best interest of the industry at this point to consider something like that. Nobody's opposed to things that are better, and we expect in the future that the cost of those detectors will come down substantially. And so there's no reason to really mandate anything like at this point. Once those costs come down, and all smoke detectors have both technologies, then we'll all have that anyway.
It's not just you out there talking to our representatives. You've got a group. Can you talk about the group?
Sure. I'm the director of the Rental Property Owner Association of Michigan, which is made up of other associations like the RPOA out of Grand Rapids. They have several members, and some of those groups are from Flint, Saginaw, and Wayne County, Kalamazoo, Muskegon, and so on and so forth. They meet on about an every other month basis throughout the year to try to set policy for what we're going to try to pursue proactively in the year. We also review things on a regular basis that are coming out of Lansing that we might be opposed to or we want to have some influence on. And those folks help guide myself, and they help guide our lobbying firm, which is Karub and Associates out of Lansing.
So far, what you've discussed has been potential bills at a state level. And there's one more on my list here.
There is one more, rent control. We've heard a lot about that in this session as well, but I'm talking about last session. It came out of the east side of the state, a bill to enable locals to enact rent control legislation in our communities. And there are a lot of good reasons why that shouldn't happen. And economists are pretty much agreed that is one thing. It does not usually turn out the way those who are advocates for it would like it to. It ends up being a negative for the very people they're trying to protect.
I used to live in Santa Monica, California, where they had rent control. But for those who are not familiar with rent control and what it really means, give it to us in layman's terms.
Well, it can vary depending on the community you're in, but generally speaking, there's some form of rent control in the actual rents you can charge. So they might say, okay, everybody's rent is locked in at what it currently is, except for it can go up by the amount of inflation until that tenant moves. And then once that tenant moves, you can then adjust your rent to the market rate. So if you have a tenant that's with you for 10 years, the most you could ever raise the rent would be the cost of living. So that's just an example of how they might do that. You can see that that can be problematic. It can discourage improvements to rental property. So you want to rehab a building, but when you look at the numbers, because you're tapped out in terms of how much money you can get because of rent control, that project's going to go to the wayside. You're going to move on to something different than that. And usually what happens is you'll build new housing, which creates more competition for the other existing housing and all of those types of things. And also other things that happen, and they found this out to be true in New York, is that as the incomes of your tenants go up, they tend to stay in your lower cost units, because why move if they have lower rent? If they move to another unit, they're probably going to move into a market rate unit. So what ends up happening over time is that those who have more money and can afford a higher price unit don't move, taking up the units that are lower priced for those folks who really need them. So a lot of crazy things can go on with rent control.
Yeah, and I'll just tell you what I witnessed in Santa Monica, very much along the lines of what you just said, is it's great for the people who have been in a property for a long time because they have controlled rent, and the rent in Santa Monica, I think it went up 3% a year. But what it does is it limits the availability of more affordable rents, because anything that does come online, the market price is pushed so high because landlords are fearful that they're going to get locked in at a low rent for the next 10 years. So they push the rents as much as they can. Plus, on top of that, just like you said, if they have a tenant who's under rent control, they're less likely to spend money to improve the property because they can't get a return on that investment.
That's right.
Yeah. So what is the status of rent control in Michigan? What's the conversation like?
Well, it's come up again in this legislative session, and there's some discussion on it. I don't believe it's going to get traction for all the reasons we just talked about. Most legislators who are smart enough to understand business and economics get it. And I think it will stay where it needs to be, which is off the table at this point.
Good. What about at the local level here in Grand Rapids?
There have been some advocates from tenant groups asking the city commission for rent control. But of course, the city knows under the current rent control laws in Michigan, the cities cannot enact any ordinances related to rent control. And they're not pursuing that at all. In fact, I'm involved with the Housing Advisory Committee with the City of Grand Rapids, and rent control was not one of the things that was even discussed or put on the table to address the affordable housing issue currently. A lot of other good things were, and some things that will really work, but that was not one. So that was actually good to hear.
Okay, well, we'll get into that advisory committee that you're a part of. But before we do, I want to talk about current legislative activity for 2017 and 2018. What's going on out there? What have you dealt with so far?
Well, the first out of the gate, we partnered up with a couple other associations in the state. One is the Property Management Association of Michigan, and then also the Apartment Association of Michigan. The PMA of Michigan actually took the lead on getting a medical marijuana bill passed. We all jumped on board to get support for it. And as you know, if you're in Michigan, you may have heard that you can now deny the smoking or cultivation of medical marijuana in your rental units. And this kind of fell in line with some previous decisions made by folks at the state level under the medical marijuana discussions that this should be allowed. There are a lot of good reasons for it. So we were successful in doing that right out of the gate in this particular legislative year. And that is the first one that's been passed. We've got some other ones that we're currently pursuing.
So wait, stop. Let's talk about this medical marijuana for a second. So are you saying that me as a rental property owner, I own multifamily, if we have a non-smoking policy, like you're not allowed to smoke anything, was there a danger that people who use medical marijuana I would have no choice but to allow them to smoke it in my units?
Sure. The real problem was that the jury is out on a lot of this because we don't know what would have or might have happened. Most attorneys would tell you that marijuana is still a federal crime, so if your lease says you're not allowed to commit federal crimes, you can deny the smoking of any kind of marijuana, regardless if it's medical or not. Other opinions by attorneys would hold that if you have a no smoking policy, you can deny the smoking of marijuana. But when it came to medical marijuana, that's when the gray starts moving in. If on a local or a state level they allow the smoking of medical marijuana, does the fair housing laws cover that? Meaning that do you have to make a reasonable accommodation for someone smoking medical marijuana and allow them to smoke it even though you don't allow other tenants to smoke, period. So it opened up a can of worms, made it very challenging, at least in that respect. Fair housing was a little bit of one of those issues where you didn't really know one way or the other how that would come down because, once again, there was no federal fair housing laws saying you had to make a reasonable accommodation for medical marijuana. But there are state and some other inferred local laws, such as the City of Grand Rapids allows you to, possess so much marijuana, whether it's medical or not, without consequences. So there are issues around it, very confusing. But on top of that, you can get complaints from other tenants about other tenants smoking marijuana of any sort, including medical marijuana. It has been proven that it draws additional crime. Someone who's growing medical marijuana, they're broken into more frequently. Those who do not have the license to smoke it or the authority to smoke it or stealing it. And also it creates issues within your unit if they're growing a lot. I think it was 12 medical marijuana plants for any individual grower, so that could really be a great number of plants in a unit. And there's also some units that were rented solely for the purpose of growing medical marijuana, and no one actually lived there. So a lot of crazy things came out of that, and hopefully this change in the law will change that.
So the change in the law says that as a landlord, I can still prohibit the smoking of medical marijuana.
Yep, as of April 10th this year, you can put a clause in your lease that says you're not allowed to smoke medical marijuana, or you could use an addendum, however you want to do it. We have a medical marijuana addendum free for our members to use, in addition to their lease that's available now on our website.
So it's understandable that with medical marijuana laws that this issue would come into question. But it also seems logical, I'm sure, to you and me, that as landlords, we should have the right to say yes or no to the smoking of marijuana on our property. Were there actually legislators out there arguing in the opposite direction?
There was very little opposition to this particular bill, which actually surprised me a little, to be honest with you. Normally, we would see somebody come out and support or be opposed to something like this, and it usually would be folks from the fair housing and marijuana community, medical marijuana community especially. those who are advocating for medical marijuana. But we didn't see that. At least we didn't see that in the way that I thought we might.
Okay, good. Well, it's good to see that logic can sometimes prevail.
Sure, absolutely.
What else is going on legislatively here?
Well, we've got some bills that we're working on drafting now. One that folks are probably really interested in is a bed bug bill. The Property Management Association of Michigan has started that bill last session.
Will you be outlawing bed bugs?
Well, we like to outlaw bed bugs. They just listen. They don't. And we can't arrest them. They're just too small to get little handcuffs on. But
I'll invent those.
This particular bed bug bill is going to clearly outline responsibilities both from the landlord's perspective and the tenant's perspective and who has to pay for those costs. So that's where we're at with that bill. The final language has not been drafted, so it's really technically not a bill yet, but we think we're getting pretty close on that. And our folks at the Property Management Association of Michigan have been great to work with on this.
So what are the arguments, and which side are we on?
Well, we're obviously supportive of any kind of legislative activity that would make it clear about where the responsibilities lie. And essentially, in a nutshell, we have to provide a bed bug free unit to our tenants. And if bed bugs arrive, it's the responsibility of the tenant to work with us and to pay for those costs if there are bed bugs in their unit. And of course, it would be negotiable about the shared portions of those costs if it was an entire infestation of a building, if you couldn't determine who brought in the bed bugs. So it's helping clear all those things up and because right now there's nothing that talks about that really anywhere except for the International Property Maintenance Code, which does make it clear that it's totally the responsibility of the tenant in a single family home, but it's a shared responsibility in a multifamily building. But when you say shared, what does that mean? So this law helps clarify what that terminology might mean.
Okay, and you and your group are helping shape this law?
That's correct.
Fantastic. What else are you doing?
Well, we've got a bill out there that's actually in the Senate. We call it the Tenant Permission Bill. This particular bill clarifies when a tenant has the right to refuse a municipal government inspection for rental purposes. So currently, if you're in a community that carries out rental inspection certification, then you would have to allow the city to come in if the tenant says that the city can come in. But if the tenant says the city can't come in, you have some communities that say, oh, that's okay, but Mr. Landlord, you're going to pay a $500 fine for not, allowing us to get in. Just let us know when that tenant leaves. So that's a problem. And also there are some communities, and it tends to be the smaller communities which they have tried to force their way into rental properties when the tenant has said no, and that's just a violation of their U.S. Amendment rights to deny, access to a government unit. So almost all district courts, U.S. district courts in the land have already ruled previously that cities can have an inspection program, but they cannot force their way into a rental property and have to respect the rights of the tenant to refuse the inspection. But if the city feels like they must come in, they have to get administrative warrant to do so. So this particular bill kind of straightens up some of the language in the existing laws in the state of Michigan and makes it very clear when the city needs to get approval from the tenant or when they need to get an administrative warrant. And if they just choose not to get an administrative warrant, they can wait until that tenant moves, but they certainly can't penalize either the landlord or the tenant for the tenant, using their rights to refuse the inspection.
That's good. I heard from a listener a couple months back, a listener from Colorado, who was telling me that the city there, they will come in to do inspections with police officers who are wearing body cams and recording their inspection.
Wow,
on those body cams.
That's pretty scary stuff.
Yeah, and his residents were low income residents. So you can imagine how much this would have, upset them.
Well, I can contend that those tenants certainly had a right to refuse those inspections. And the city needed to jump through that little hoop of getting that administrative warrant to do that. And I would even question whether or not having a police officer there with a camera would be even permissible, because the inspection is not to determine whether there's criminal activity. The inspection is to determine the health and safety of the unit. So you have to have probable cause to do these kinds of things, and it's kind of always been that if having an ordinance that says rental properties have to be inspected is perfectly fine, but if you want to go in against the will of the tenant and treat it as if there's something wrong, then you need to get an administrative warrant to do that. Yeah,
perhaps there are some cities out there that choose to overstep their boundaries.
Oh, absolutely. I think we all know that some communities are less favorable when it comes to rental properties, and especially in some neighborhoods. They treat certain neighborhoods differently than others, which is very unfortunate.
Yeah. What else you got for us?
Well, there's something we've been working on for a very long time. We're going to see if we can make it happen this time around. If you have an LLC, you hold your properties in an LLC and you try to do an eviction, you'll probably found out that you go to many courts. They say, boy, you can't do that on your own. You're going to need an attorney for that. So that's very frustrating. We've been attempting to get that changed for several years, and this is going to be a bill we're starting out with, which we negotiated in the last session, which we thought got very close to happening. Basically would allow mom and pop LLCs, single member LLCs, to go to court for themselves, represent themselves without an attorney up to the limit of small claims court. And we think that's fair. And that bill is out there now. We're starting to get some feedback, and I think it's probably not hard to figure out who the opponents to that would be. Right out of the gate would be the Bar Association. So we've got our work ahead of us. We're going to keep banging on that one.
Wow, so you're fighting the lawyers on this one.
Well, to make the attorneys happy, though, we're working on taxable costs, which for another definition of that is what you can collect for attorney's fees for an eviction case when it goes to court, whether that be for the first hearing or for a trial. And we're going to try to get those increased. We do that about every 5 or 6 years, because as time goes on, those the costs continue to go up. So we're going to continue to shoot for that at this point.
So evictions, if I own a property and it's in my name, I can go through. I can handle the eviction process myself.
Yes, that's correct.
But if I own that property in an LLC, currently I cannot. I have to hire an attorney to do it.
That is what the courts have contended. They're using the idea that an LLC is a corporation, which it is not in this state, a corporation, but they are looking at it as one. So the corporation is a entity in of itself. So if you represent that corporation, you must have a license to do that. So that's where they try to get you. And they've so far have held that that's the way it should be done.
All right, and you're close to getting the support and getting this bill through.
Well, it's just getting started. So in this particular one, I wouldn't venture to say that yet.
And when you say it's just getting started, last year during the last legislative year, you actually got it quite far along.
We got the language hammered out to where we thought everybody was pretty close to accepting it, but it did not make it in the end. Like some bills happened to just die, unfortunately. This was one of those.
Does that mean it goes back to the start?
It starts all over again in a new legislative session. And of course, some of the problems with that, with the term limits, is you have to start over with a lot of different new legislators and explain the whole thing all over again. So it can become a challenge. But honestly, I have never had an attorney or anyone tell me in this particular business that they felt a small landlord, mom and pop, single member LLC needed to have an attorney to go to court, because the reality is the person has the most knowledge is the owner of the property who's on top of it. So why shouldn't they be there? And most courts, in fact, even if you bring an attorney in, they're going to require one of the owners to be there who has the knowledge. So it's kind of one of those odd, twisted little things that has popped up we need to try to get taken care of.
Yeah, well, good luck with that.
Thank you.
What else are you working on?
So far, at the state level, we've got other than the rent control bill that we already talked about, there is another bill out there that would open the Rent Control Act, which makes us a little nervous. The language doesn't really talk about rent control per se. It really would just give authority for communities to enact certain types of zoning changes to make it easier to build affordable housing for developers. We're just keeping our eye on that one, working with the Builders Association and the realtors to make sure that that particular bill doesn't become something that we don't want it to become. So far, doesn't seem to be a big issue, but like I said, we're going to keep our eyes on it.
Yeah, so to be clear, you're not against creating more opportunities for affordable housing. You just want to make sure it doesn't Frankenstein into something that's going to mandate it.
Absolutely. And really, we don't see a need for this particular legislation. We don't want to be opposed to something that obviously would be beneficial for everyone. Communities like Grand Rapids are already considering doing some of the very changes that this particular bill would say they're allowed to do. And I believe the city of Grand Rapids feels like they're already allowed to do them anyway. So I understand that the legislators sponsoring this bill is from an area where there are a lot more restrictions on what can happen, and this bill would help open the door for that particular area. So if it's going to help them solve a problem and it's not going to create more problems for everyone else, I guess we can support it.
Great. Now, on a local level, you've been working with the city of Grand Rapids to address affordable housing issues.
That's right. As many folks probably know, there has been tenant advocacy groups out there asking the commission to do something about the affordable housing issues in Grand Rapids, and I think we're all well aware of why that's happening. There's scarcity in the market. A lot fewer rental properties are available, so everybody's out there struggling to find one that they can move into, and then when they do find one that they're interested in moving into, they have a lot of competition with other prospective tenants to try to get into that rental unit. So it's become tough, and the main reason is there's not enough housing in that income level in this market for those who can afford, let's say, the lower to moderate rents. So the city of Grand Rapids decided to establish a housing advisory committee. They've been meeting over the last several months. In fact, they just had their last meeting, and they have about 10 recommendations that they've come up with that's going to go before the commission over the next couple of months.
What's coming out of that? I mean, what are some of the ideas that you're seeing?
Most of the ideas would improve density, the ability to build more units on a smaller parcel of property, change some of the parking requirements, not having as much parking required, changing setbacks and some of those things, essentially lowering the cost of doing housing for lower income families. Currently, it's nearly impossible to do that without heavy tax credits and incentives. But they're also looking at putting in place something called a pilot program, which is a payment in lieu of taxes, meaning that if you're going to build low-income units, that a portion of the rent will be collected, say 1% to 4% of the rent will be collected for those that have been filled, and that goes to the city in lieu of paying property taxes. So that would be a huge cost savings to a developer when they're looking at doing that. So they could choose to build all lower income units, or they could choose to do a mix of lower income with other units. And I think that's what most developers are looking to do at this point. But there's also a affordable housing community fund that the city has been working with, and they're talking about how to fund that and what those funds might be used for. None of those things have been nailed down yet. There's some speculation about what they could be used for. They could be used to help assist with tenants with paying past due rent. Could be used to help them pay for application fees. Could be used to pay for, in part, community management. Could be used to pay for, eviction prevention, all kinds of things. It could be used for maybe to subsidize costs for developers to build more low income and affordable housing. So none of that has really been nailed down yet, except that they want to do it, and that continues to move forward at this point.
So it does sound like there's a lot of positive progressive ideas that will help developers and create more affordable housing and provide more affordable housing. But as a member of the Grand Rapids Housing Advisory Committee, do you ever find yourself confronted with ideas from either the public or other members that would really, in your mind, be detrimental?
Well, there were a few things that came out of the discussions, and one of them actually was left on the list of the things that got recommended to the commission that we'll all see over the next coming months. And one of those things was to address the cost of application fees, meaning that the city might consider developing an ordinance that would say you can only charge so much for an application fee, or if you fill your unit before you've gotten to the next 3 or 4 applications, you'd have to return the application fee for those that you didn't actually go through the process of screening them. Of course, our argument is that you can't control all the fixed costs around screening, which is paying for credit reports, criminal reports, and all those types of things, and for staff to do the screening. And that we're currently not charging way over the cost of doing those reports. We're just trying to recapture the expenses that we have into doing that on the average. So it would be very cumbersome for the city to get involved in our business activity. So we're going to try to prevent that from happening. Other discussions were maybe not quite as difficult for us to swallow, but we'd still rather them not. Would be saying that we have to, hand a tenant the screening criteria before they fill out the application, which of course is standard industry practice already. We recommend doing that for all your tenants or your prospective tenants, so they can know what you're looking for. But they would also, for all instances of denying a person a rental, you'd have to inform all tenants about why you denied them, even if it wasn't for information found on a credit report or a criminal report. So just a lot more administration they would be requiring of us. And I think probably the most important part, though, to take note of is that will have little or no impact on affordable housing. So why is it on the list?
Mm-hmm. So you'll be speaking out against that as you go forward? Correct.
Right. And we've already begun that process by talking to some of the commissioners and the mayor about our position on those various things.
So, as we wrap it up here, Clay, are there any other legislative issues out there that we should be thinking about or that you're facing? And, any warnings for us and for our listeners that we should be looking out for?
Well, we're hopeful that some things will come out of the federal government at this point. We work through our national association, the National Real Estate Investors Association, to address some of those things. We'd like to see some changes to Dodd-Frank, so we keep our fingers crossed on that one. But otherwise, I've been working in the city of Grand Rapids on other frustrations some rental property owners have been facing because we're growing so fast and because there's so much building going on. Mechanical inspectors and electrical inspectors are very, very busy, struggling to get out to do inspections. But that really runs up against a real issue when a rental property owner has been cited, for instance, to replace a furnace or a water heater or those types of things that require a permit and a follow-up inspection. That if you're only given so much time to get that done before the city decides they need to send you a condemnation notice. But the reason why you can't get it done and cleared is because the inspector can't get there in a timely manner. Then we've got, we're kind of running up against the wall with them on that one, and we're going to try to figure out how to resolve that situation. Certainly not our fault that the city inspector can't get to the job site as quickly as we need them to get our certification.
Yeah, I'll give you an example of that. I have a property, multifamily, where the city came out to do an inspection over the winter, and some of the things that they requested, such as exterior painting and a few other things, I think some concrete work, obviously can't be done during the winter.
That's correct, and there's usually a delay on that kind of thing in those orders. Sometimes those that date in which they say you need to get it done by is a little earlier than what it probably should be in Michigan because we still have bad weather in April sometimes. So,
yeah. Well, I have a management company that takes care of these things for me, but just because we let them know, hey, it's going to take longer. We have to wait till warmer weather. And then of course a couple months later I get a bill for $250 for not doing what they told us to do. and
believe it or not, we're talking about that as well. We're trying to figure out how to get around that one. And it all becomes technicalities on their part. Well, it is a violation. So you're getting sent a fee
what I got sent was a notice to prosecute. They were telling me, oh, guess what? We're going to prosecute you now because you haven't done what we told you to.
Yeah, well,
and here's a $250 bill on top of that.
In some of those cases, you can appeal them and you can have success, but that isn't always the case. It is, because we're always trying to prove our side of the story and trying to get city staff to understand that everything that they do impacts the cost of housing in the city, whether they're towing the line and doing what they think is the right thing to do, and hey, they're just being told what to do and here's the rules and they can't venture from that. There's got to be some common sense in this if you're going to have affordable housing, especially in lower income neighborhoods.
Well, I actually do think there is common sense on their part, because their common sense is saying, let's bilk the landlords and the property owners so that we can raise more money for the city. And just keep doing what we're doing, because it just makes us more and more money. If we were to really address it, then we wouldn't be making as much money. But if they were to really address it, maybe the housing would not be so much more expensive for the residents.
Well, it certainly seems that way, and it's very easy to go down that road. I try to be less cynical because I think I need to be, but you're right. It does clearly look that way, and we need to work with the city to try to get those things changed so that that perception is not reality.
Yeah. Well, it's not perception on my part. It is reality.
Sure.
Because I can show you the bills.
I can
show you the bills I've gotten from the city for things that I scratch my head and say, wait a minute, they're going to prosecute me now, and I got to pay $250. It's just never ending.
Yep. And I think everybody should know that's what we're always staying on top of, constantly reminding the city of that, talking to them about fixes for those problems. It can be very challenging to tease out of a lot of different situations about when the city is justified and when they're not. Oftentimes the city will go out of their way to justify their position. Sometimes I have to sit back and agree, yeah, you're right, that should have happened the way it happened, but there are a lot of times when it shouldn't have, and I will give the city credit. And they just did this recently on a job where a developer bought a property. He's out of town, bought a property in town from a local person. There was an issue with permits being pulled and a water heater being installed, getting the final inspection, and so on and so forth. Make a long story short, the new owner got fined because the previous owner didn't do what they were supposed to do. But we were able to show how that probably shouldn't have happened, and that it was gouging, and the city was pretty quick to reimburse the current owner for those fines. So there are situations when you bring things to the city, they look at it and they work with you and they do reverse those things. So I get the message here would be for everybody, don't just rely on what happens with an inspector. If you aren't getting what you think you need with an inspector, you need to go to their supervisor. And if their supervisor doesn't agree with you, you have to start making a call of either contact the RPOA, and we'll try to see if we can run it up the chain of command, or I should say, you need to appeal it, and then we need to do both at the same time to try to get the situation resolved. Letting things go, just complaining to yourself and your friends about things the way they happen, we don't catch them. And if we don't know about them, we can't do anything about them. So it's important. Just within the last week, we had resolved two situations where at least at one point those fines were returned, and the other one, a property was being condemned for the lack of heat when brand new heaters were installed and were working. And of course, it's been 60-some degrees, so there clearly isn't an emergency about needing heat in the unit. But they were going to condemn the house anyway, ask the tenants to leave. So there's no common sense there whatsoever. And with a little bit of help from us, a little bit of push, everybody seems to be getting on board and getting those inspectors out there and to get that job done.
Yeah, and that's another function that the RPOA serves, is just standing up for the landlord, for the rental property owner.
Right. And sometimes, we meet with certain, and sometimes it ends up being newer property owners who don't understand all the rules and regulations. And you have to kind of sit down with them and go through maybe a notice of violation they got when they were confused about why they got, a violation for something. And if you go over that, then they feel a little more comfortable with things. But sometimes you find things that are just, it boggles your mind, and you can't quite find in the code what they're talking about. So, but we have to be there and be diligent to follow up on those things. Otherwise, things could really get scary.
So what I would like is for the people listening to this to really think about, what kind of rental property owners they are, and think about how the RPOA is out there serving their needs, whether they're members or not. Preventing some of these laws from happening, working with the city to basically help landlords in these situations. And I would ask you, Clay, what action do we want listeners to take after listening to everything you've just said?
Well, there are two really important things to do, and one is obviously we need funds to support the work that we do from the association. So, members is what makes that happen. Membership dues are extremely low. We try to keep those low so that rental property owners and real estate investors can afford the investment, and it really is an investment in their business to help prevent these things from happening. And then when we do positive things to make less cost for property owners, everybody saves money in the long run. Just for instance, in the city of Grand Rapids, we were able to put a 2, 4, and 6 year inspection certification cycle in place. It used to be every 2 or 3 years. That has saved a lot of property owners hundreds of dollars, if not thousands of dollars, if you understand this process, how things usually go. So we're there to help you, and we encourage you to be members, stay members. Even if you don't need us for something right now or within the next 3 or 4 months, you have to understand that we're always there watching your back, trying to take care of things behind the scenes, both locally and at the state level, and communicating to our national group things that would benefit us if we can get things changed at the federal level. But in addition to being a member, one of the things that our organization is involved with is interviewing candidates that are running for office on the local and the state level, and we provide PAC contributions to those individuals. So what we need is funds for our PAC fund. So if you want to be a member, you can go online to our website at rpoaonline.org and choose which type of membership you'd like. Or you could call our office and we can get you started on making a contribution to the Political Action Committee and helps us support those candidates that support our industry.
And the phone number for that?
Is 616-454-3385.
Okay, so let's repeat that. If you want to become a member or to find out more, you can go to rpoaonline.org.
That's right.
And if you've listened to this and you feel as strongly as I do that what the work the RPOA is doing in their Political Action Committee, and you want to support that, call the office at what number?
616-454-3385.
And you can make a donation that way.
Very much appreciated. We're getting ready to go into interviews right now with those who are running for the city commissions in the various cities in our area, and those funds will help us support and do that. Excellent.
Well, Clay, thanks so much for coming back to the show and sharing what all your successes and some of the scary things that are out there that we've been able to avoid because of the work that you're doing.
Well, Brian, thanks for giving me time to do this. We always like to communicate what's going on, and especially when it's the good stuff.
You've been listening to the Rental Property Owner and Real Estate Investor Podcast, brought to you by the Rental Property Owner Association. You can find out more at rpoaonline.org. If you enjoyed this podcast, please go to iTunes to subscribe, rate, and review.